This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we get started, just a couple of things. If we don't anticipate any technology related problems, but if we should have any, we'll just everybody take a deep breath and we'll take a pause, and our experts will get it fixed, and then we'll pick back up. Mr. Hibner, call the case, please.
Wilmington Savings Fund Society et al. Versus Estate of Sallie L. Miller.
Oh, we'll hear from the appellant.
Oh, it's ready. I'm ready now.
Yes, Ms. Franklin. Yes, you can go now.
Okay. I'm Esther Franklin. I was a correction officer for 13 years. I've been in this house ever since 2002, and I've been paying the mortgage. I've been paying the taxes. I've been paying everything. I came into a problem when it switched over to Rushmore. So when it switched over to Rushmore, I paid Rushmore because I had got hurt on my job. I paid Rushmore $2,000. I paid them $2,000 so much. I paid them up to $4,666.05. I did that because I was going to be off of work for a minute. Okay, so they took that, accept the money and everything. And then she called me back. The lady called me back, and she waited about a couple of weeks. And she said, is there any way that you can pay the whole rest of the full amount, like $34,000 or something like that? And I was saying, I can try my best. I said, but I'm going to be off of work. That's the reason why I paid ahead of time. So I talked to an attorney because I was saying, okay, she was rushing me. So I talked to an attorney, and she said, well, can you bring me some papers? I said, yes. I brought her this note that I had got from the Knoxville Area Urban League, where they did a loan for me to THDA. So this is the loan. This is the paper that they gave the court, and it has a little seal on it. This is the one I got from Keep My Home, Tennessee. They sent this to them. Okay. Not only that, I asked them about the account. Each time I asked about the account, they will never return no calls. These account numbers don't even match. They match to the account that's closed. This account's supposed to have been closed. That's the reason why the seal is at the top of this. All I have been trying to do, sir, is pay them. I didn't know it was from what I know, when I moved here, it was $32,000. That's what I was thinking I was paying on from 2002 all the way up to 2015. And I was saying, it's taking a long time to pay this $32,000 off.
Ms. Miller, did you ever receive permission from them to actually acquire or purchase the house?
Have I ever seen from them?
Uh-huh.
Can you say it again, sir? Because I didn't understand.
Okay. Who did you receive permission from to purchase the house? How did you go about purchasing? How did you go about becoming owner of the house?
I had a quitclaim deed, and I was dual power of attorney for my auntie.
Okay. Now, what about the mortgage company? Did they consent to your purchasing of the house?
Yes, sir. They have the facts. They knew it. And then, matter of fact, they put it in my name. It was put in my name where they drew money out my account.
Now, did you present this proof at the trial court?
It should be in there. Yes, sir. It should be there.
Okay. Go ahead.
And also, I look back, and this should be in there too, where they have different dates. This is supposed to be this is June the 10th, 1997. Mm-hmm. All these numbers are so confusing that they don't even match. And each time I ask about them, they'll say, I'll get back in touch with you. But I had to keep on continue paying this money because I didn't want to be put out of my house. And so when I got the lawyer to talk to, when I got Paige Coleman to talk to them, it was a whole nother story. Then they refused to call me back. I had a loan for them right before when they foreclosed on me. I've been doing everything in my power, sir, even during the death of my sisters. I had a sister and a brother that died. I got them right behind me. The sister and brother that died, they obituary. This is Sallie Miller. This is my auntie. I try to do everything I could in my power to pay these people, continue to pay them. Every time I turn around, it's just more money. It's more money. We add this up right here, it's over $119,000 or something like $190,000, including the balloon payment. This is their paper. Like I said, this is their paper. My paper, the paper that they gave to get the loan from Keep My Home Tennessee, do not have that seal on it. They have all of these papers and stuff do not match. And when I asked about it, they put the court dates off, so I got to wait, scramble to get another lawyer because Paige lost her. She lost her business because she didn't have enough clients, and then she turned her back on me. So I had to go to the courts and try to do what I can, find other attorneys. They said it's a mess. Everybody looked at it and said it's a mess. And they try to call the company. They try to talk to Rushmore. Rushmore will not return any calls. They'll put a court date off, then they'll come with a court date right around a holiday. And that's the only time that I can get in contact with them. When they say, can we put the court date off and whatever, and I'm saying, hey, I got this money, I got this loan, so we won't have to go through this. They refuse to even listen to the loan. They refuse to even take the loan. Here I am in a standstill. I don't know which way to turn. I go to another lawyer to get them to try to get them to help. They'll call them and try to get the information. They would refuse to give information. I put a paper in there showing that they did fraudulent loans. It's in my file. I looked it up again. Rushmore been sued for doing false documents. Her signature don't even match some of her signature doesn't even match this note.
So one other thing I want to ask you, in the trial court, when the motion was filed for summary judgment, did you file a response, or the judge found that you did not file a response to that motion, a statement of undisputed facts?
It was during COVID time. So the mail was late. Only way I knew that was, and I went up there to go, I hadn't heard anything. So I goes up to the courthouse, like I run all the time, up to the courthouse. They gave me that paper. By the time they gave me that paper, I couldn't even respond. I tried to write out something to them in a hurry. Like I said, due to COVID, I couldn't go to court. I couldn't plead my case in court. They came to court. The mail was late. The mail was behind like a month late. You know it yourself. The mail was late. There's no way I would not have missed that to try to keep my home. There's no way I would have ignored that. There's no way. And I done paid over $11,000 in court costs. That $11,000 is something could have went toward, plus the $6,000. That could have went toward me paying the house off and then pay them the rest of the money. So what I don't understand is why. Okay.
Anything else, Ms. Franklin?
Is my time up?
No, you still have about 1:50 seconds, plus you'll have your rebuttal time as well.
Okay, I'll just go ahead and take that rebuttal time.
All right, you'll have your time for rebuttal after the other side finishes theirs, and I'll tell you when. Okay.
Yeah, thank you.
We'll hear from the appellee.
Good afternoon, Christopher Baxter on behalf of appellee Wilmington Savings Fund. This case is an unlawful detainer action stemming from a 2018 foreclosure of the property located in Knox County. We've briefed the issues in our brief and rely on that, but I can provide a bit of background for the court. In November 2018, appellee Wilmington Savings was the winner at a non-judicial foreclosure action. Then into the next year, July 2019, Wilmington served a notice of quit and demand for possession of property on the appellant. Following the refusal to voluntarily surrender the property, a detainer warrant was filed in Knox County General Sessions Court. In August of 2019, judgment for possession was granted to Wilmington. The appellant appealed to the circuit court in Knox County, whereupon a motion for summary judgment was granted and the present appeal followed. The appellant possessed, prior to our coming in, we were the successful bidder at the foreclosure sale, but we understood that the appellant possesses the property through a deceased borrower, her aunt. Upon our awarding of the property, she at that point was a tenant at will. And of course, within the action, or within the circuit court case in Knox County, the motion for summary judgment with the undisputed facts that the plaintiff Wilmington at that point, we were the owner of the property by virtue of the trustee's sale. The court, within the documents in the summary judgment, even if the documents were considered as a proper response, the summary judgment action, which there was no response, Wilmington would still be entitled to summary judgment. Nowhere in the appellant's brief in this action does she point or specify that there was an error in the trial court's judgment. We would ask that the court to similarly affirm the circuit court's judgment from 2020. And unless the court has any other questions, we can leave it at that.
I hear none. Thank you. Ms. Franklin, you have the 5 minutes you reserved for rebuttal to respond.
Yes,
That's it. Okay, you head down.
Okay, they did not give me the proper time. I could have paid the loan off. I asked them to let me pay the loan off without me being evicted. They refused to even answer any questions. They refused to even talk to me. And like I said, at the time, it was something else he said I couldn't get. At the time, all that was going on, I tried to reach out to them. I tried to reach out to them with loans that I had. They failed to respond to. They refused to respond. And like I said, I have the will to stay here. I had a life estate in my name. I had an auntie that gave me dual power of attorney, special dual power of attorney to handle her affairs. They agreed with everything. They agreed when they took my money out of my account. They agreed for me to be here until they found out that my house is more than what they thought it was. And that's the reason why they're wanting it. That none of their accounts match. Nothing that they say, I can't believe anything they say. That's the reason why I went back and forth to the court. I have just as much right to this house as they do. I've paid in multiple. I've been paying ever since 2002. I've been in this house for 20 years, sir. I had to do repairs in this house. I didn't stay in this house for free. I had to do repairs. I had to buy hot water tanks. I had to buy an air conditioning unit. I had to keep this house up. And if I could not have afforded, they could have gotten this house and they would have had a good house. I took care of it. I worked hard for everything I got. I'm disabled due to my job. And all I want to do is be able to stay in my house, continue in my house for the rest of my life. That's the reason why I worked hard for it.
Anything else, Ms. Franklin? You still have some time. Anything else?
I just asked the court, could they please grant me my house and I can give them their money. I have a loan. I've been having loans. I done gave them offers and all. All I want to do is have my house. They the ones keep putting it off for court, putting the courts off and holding y'all up. I've been ready every time. I've been ready each time to go to court. I've been ready each time. They put us in this predicament. And all I ask, and I don't want, and then I done paid all the court costs off. I don't owe the courts anything. All the thing I owed them when it started was $39,000. I can pay them their $39,000, sir, and continue to stay in my home, if it pleases the court. Thank you, sir.
Thank you, Ms. Franklin. The way the process works now, the case will be submitted to this panel, 3 judges here, Judge McClarty, Judge Golden, and me, and we will arrive at a decision, and we'll do a written opinion on it, and judgment, and we will send you a copy of it at the same time that we send one to Mr. Baxter, so you both will be notified the same way at the same time.
Yes, sir.
All right. Okay. Thanks to both sides for your arguments. Mr. Hibner, if you'll recess court till our next scheduled case.
This honorable court is now in recess until 2:30 p.m.
Thank you.
Thank you.